Hi, I'm Taylor Kiesig. I'm a partner at Eversheds Sutherland.
And I'm Engin Narol, an associate at Eversheds Sutherland.
And today we're going to talk to you about the recently proposed regulations under Section 163J. Section 163J was enacted as part of the Tax Cuts and Jobs Act and operates to limit the ability of taxpayers to deduct business interest expense. On November 26th, a 439-page package of proposed regulations was issued that clarifies the statute. But before we get into the proposed regulations, Engin's going to walk us through the statute.
Thanks, Taylor. Under Section 163J, a taxpayer's deduction for business interest expense is limited to the sum of 30% of the taxpayer's adjusted taxable income, the taxpayer's business interest income, and the taxpayer's floor plan financing interest. Now, Section 163J is quite broad in that it applies to all businesses, not just to corporations. It's also broad in that it applies to all interest payments, not just those between related parties. Now, there are certain limitations under 163J in that it does not apply to certain small businesses or to certain types of trades or businesses. Any amount disallowed under 163J can be carried forward by a taxpayer to future years.
So, as I mentioned, the proposed regulations are long and they're broad and technical. Today we're going to provide an overview of some of the high points of what's in the proposed regs. As expected, the proposed regulations provide definitions for terms like adjusted taxable income that are necessary to apply the limitation. They also provide some surprises.
That's right, Taylor. For example, the proposed regulations define interest in a very broad way, picking up items that you wouldn't normally consider to be interest, such as commitment fees.
The proposed regulations address the treatment of historic 163J carryforwards, providing that such amounts are generally treated as business interest in subsequent years and available to be deducted subject to the application of the new limitation. The proposed regulations also coordinate the application of Section 163J with other provisions that impact interest, generally applying that this limitation comes after other limitations. One notable exception is that the proposed regulations do not address the interaction of Section 163J with the Base Erosion and Anti-Abuse Tax, or BEAT, and we expect that to be addressed under regs forthcoming on the BEAT provision.
The proposed regs clarify that the limitation would apply to consolidated groups at the group level, essentially treating the group as a single corporation for these purposes. The limitation would also apply to pass-through entities such as S-corps or partnerships at the entity level, creating a complex system of calculations required to figure out exactly how much interest is deductible.
The proposed regulations provide that for non-U.S. entities with effectively connected income, the Section 163J limitation applies, as it does to controlled foreign corporations, which means that this limitation has to be taken into account in calculating other provisions under the code. Finally, the proposed regulations offer guidance and definitions around what are accepted trades or businesses, generally real estate, farming, and certain qualified utilities, and offer guidance for allocating items between accepted trades or businesses not subject to the limitation and trades or businesses that are.
Thank you for watching our video. For more information on this and other topics, please visit our website at eversheds-sutherland.com.